I welcome you all to Legally Yours, Center for Legal Studies, powered by Chandigarh Civil Services. In the last video, we dealt with the introduction of the Himachal Pradesh Urban Rent Control Act 1987. Today's video is with respect to the definitions. We have a lot of definitions, that is why we will be covering it in two videos. So without much ado, let us first look into the recap. In case you have missed watching the previous video, what all we covered there, from the pre-point of view, we discussed what is the jurisdiction of the Act that is given in Section 1, subsection 2. Thereafter, the date of enactment, enforcement, and the appointed day. Then the preamble clearly stated the extent as well as the scope of the Act. From the mains point of view, we have covered what urban implies as per the census of 2011. Here I would like to rectify by the end of the video that where does the definition of urban stand with respect to Himachal Pradesh. Thereafter, a mains important question of historical background was covered in detail. And from the interview point of view, we learned about the formation of Himachal Pradesh. Today, to begin with, I would like to highlight the constitutionality of the rent legislations. So, under the Indian Constitution, number one, housing is a provision given to us as a state subject. Apart from that, even land is a state subject. So, we know that there is Schedule 7 of the Constitution, in which the list 2 deals with state. Their point number 18 is with respect to land. So both the housing and the land, they are a part of the state, and that is why any rent legislation, be it with respect to a rented land or a rented building, is governed by the state. Thus, the enactment and enforcement of these rent control laws is the responsibility of the individual states. But there's a little issue here, reason being, we understand that India has a federal structure. Thereby, every state governs the rent legislations. But when we look into the comparative analysis, it becomes very complex. That is why after 1991, the center enacted the Model Rent Acts. Now, these Model Rent Acts, either they can be adopted as a whole by the states, or the states can make amendments to their rent laws. For example, even in 2009, our Himachal Pradesh Rent Act was amended, and this amendment came into force in the year 2012. So this is the question with respect to the constitutionality. We need to note down that both housing as well as land, they are a part of list 2.18 covers land, and that is the reason why rent legislations are a state subject. Moving further, we will be dealing with important definitions, and I'll give you the tricks as to how can you learn the same. कल हमने appointed day की definition करी. So A for appointed day, and we know section 2A provides us the same. Today we'll be dealing with the definition of building. So now usually it happens in the mains, these definitions are asked as 5 markers. So apart from quoting the definition, where is the definition provided, you need to substitute your answer, supplement it with some case law or the other. तो आज हम at length दोनों point of view से, pre और mains दोनों point of view से ये definitions cover करेंगे. So in the definition of building, they stated that building means. तो ये जो term means है, इसका मतलब है कि हम legal meaning को देखेंगे, ना कि literal English meaning को. So here they clearly state that a building means any building or a part of building. Reason being, in case you're residing in a house, you might let out one room, you might let out one floor. So thereby, the building for the purpose of this act, it can be both a part of the building or the building as a whole. Now this building can be let out for any purpose. कौन से purposes हो सकते हैं? या तो ये residential purposes होंगे या फिर non-residential purposes. These two we'll cover in the next video. Now, in case the building is let out for any purpose, even if it is not being used for that purpose, it will still amount to be a building, and the landlord can claim the rent for the same, even if you are actually using it or not. Now, I would like to tell you that here the definition also provides what does the building include and what does not include. So thereby, this definition becomes exhaustive. So this definition is exhaustive. We see that any land, godown, outhouse, any land, godown, outhouse or furniture that is let out therewith is also building. So here I would like to clarify that per se, if you go to, let's say, some IKEA to get the furniture on rent, that would not amount to building, because furniture here would be that is let out therewith. So the meaning of therewith is that is given with or in the thing. तो वो फर्नीचर ऑलरेडी बिल्डिंग में होना चाहिए in order for it to be a building. So let's revise it all over again. A building would be a building or any part of a building that is let out for any purpose. ये purpose residential या non-residential दोनों हो सकते हैं. Whether being actually used for that purpose or not, and what all will it include? It will include any land, any godown, outhouse or furniture that is let out therewith. And they clearly state what it does not include. So the exception is also provided that it would not include a room in a hotel or a hostel of a boarding house. तो ये जो room in a hotel है, इसको लेके हिमाचल प्रदेश government is very strict. Reason being, we have a case law. Kundan Lal Ahuja versus Surendra Nath, back in the year 1991 itself, the Himachal Pradesh government made it clear. So the decision was that in case there is a building that is not registered within the prescribed authority, it cannot be treated as a hotel. And what is this prescribed authority? It is the Himachal Pradesh registration of hotels and travel buildings. और इसका purpose हम validly समझ सकते हैं because Himachal Pradesh में a lot of revenue is through tourism. So that is why they are administering it strictly. अगर कोई भी building को hotel count होना है, so they need to get themselves registered with the Himachal Pradesh registration of hotels and travel buildings. So with this, we complete the definition of building and we move on to 2C, that is controller. ये भी याद करना बहुत आसान है. A for appointed day, B for building और C for controller. तो हमें समझ आता है 2C provides us the definition of controller. Now many students have a doubt that the controller is vested with the powers of a civil court, so that person might be a JMIC. So here I would like to clarify that in section 2C they have clearly provided that any person who is appointed by the state government to perform the functions of the controller under this act. तो पूरे एक्ट में आप देखेंगे अलग अलग जगह पर प्रोवाइड करा गया है कि कौन कौन से फंक्शंस एक कंट्रोलर परफॉर्म करेगा. तो उन फंक्शंस को परफॉर्म करने के लिए स्टेट गवर्नमेंट जिसको भी अपॉइंट करेगी, दैट पर्सन विल बी कॉल्ड द कंट्रोलर. और कंट्रोलर विल बी वेस्टेड विद व्हाट पास. द जनरल रूल इज दैट for execution of the orders or for any proceedings of any matter of the Rent Act, he will be vested with the power of civil court. And where is this provided? It is provided to us in section 26, whereby we read that in case of any execution of order, चाहे ये order controller ने खुद पास करा हो या फिर अपील में ये order पास आया हो, this order will be executable by whom? It will be executable by the controller itself. So this is very important for you to note down. Now, this order that is passed, it will amount to be a decree of a civil court, right? Since it is a decree of a civil court, thereby our controller is vested with the power of the civil court. This is the general rule. But in section 26 itself, they provide an exception to this, that is section 31, in which they state that whenever a controller has to collect any fine, to recover any fine, in that particular case, he will be considered as a magistrate. जो सिविल कोर्ट की पावर है, they derive it from CPC. ये magistrate की power they derive from CRPC, right? So for this particular provision of recovery of fine, our controller will exercise the power of a magistrate. He will be deemed to be a magistrate under the Code of Criminal Procedure. तो कंट्रोलर की पूरी डेफिनेशन को अंडरस्टैंड करने के लिए कि उनके पास कौन कौन सी पावर्स वेस्टेड हैं, हमें सेक्शन 2C रीड करना है विद सेक्शन 26 एंड सेक्शन 31. Moving further, we'll cover section 2D, that is the landlord. Now, landlord means any person for the time being entitled to receive rent. Here, I am emphasizing on the term entitled to receive rent because ownership का element नहीं है landlord में for the purpose of this definition. Here, they are clearly stating that landlord means any person for the time being entitled to receive rent. अब चाहे ये खुद के अकाउंट पे रिसीव करें या फिर on behalf or for the benefit of any other person, both the people they would be called the landlords, right? So let's read it once. What does section 2D provide? Landlord means any person for the time being entitled to receive rent in respect of any building or rented land. Building की definition हम कर चुके हैं, rented land की definition we will see in the next lecture. Whether on his own account or on behalf or for the benefit of any other person. We have seen on their own account they are receiving, but in case they are receiving it for the benefit of somebody else, who all will it include? It would include a trustee, a guardian, receiver, executor, administrator for any person. So these five we'll be covering in the next slide. Here, I would like to emphasize that a tenant who sublets any building or land or rented land in an authorized manner, only in case a person is authorized to sublet. You are a tenant, you are subletting the property in an authorized manner. In that particular case, you will be called the landlord in lieu of the person from whom you are collecting the rent or to whom you are subletting the property. So even a tenant can be a landlord in this exceptional case. Apart from that, we have a specified landlord. So this specified landlord is given to us in section 2I, which we'll be discussing in the later part of the video. But let us first see that what is the literal English meaning of all these five. So the first is a trustee. तो कोई भी एक ट्रस्ट है, उसमें लीगल ऑब्लिगेशन क्रिएट करा जाता है किसी इंडिविजुअल पर्सन पर या किसी मेंबर ऑफ द ट्रस्ट पर, so that they can carry out the activities of the trust. So whatever the purpose is emphasized, only for that purpose they would be called the landlord. So in case a trustee, one of the members is given the legal obligation to collect the rent on behalf of the trust, so in that case only that trustee will be called the landlord. In case of a guardian, we see that a person is appointed to look after either the another person's property or the another person's person. जैसे हम देखते हैं कि माइनर के केस में गार्डियंस अपॉइंट होते हैं. Thereafter, receiver is an independent and impartial person. Now this person is appointed by the court to administer or manage. So now that implies to protect and preserve a disputed property involved in a suit. So that person is the receiver. The next two terms, that is the executor and the administrator, are used with respect to will. In case a person has clearly stated in his will that so and so person will be appointed for distribution of assets, in that particular case they are called the executor. So an executor is a person or institution who is the legal representative named in a will or implied as such to carry out the process of the distribution of the assets of whom the testator, the person who made the will. And an administrator is a person who is appointed by the court to manage and take care of the assets and liabilities of a deceased who has died without making a will, right? So in case you have died without making a will, the person who's appointed by the court is called the administrator. That is the minute difference. So all these people, in case they're collecting rent on somebody else's behalf, they will be termed as landlord under section 2D. Now there are two important case laws with respect to it. Vinod Kumar Agarwal versus the 17th ADJ, Allahabad and others, in a 2013 judgment, they clarified, एक तो इन्होंने clarify करा that it is also stated that the concept of ownership is not imported here. So here in the language of the judgment, they have clearly stated कि चाहे वो इंसान ओनर हो या किसी के बिहाफ पर रेंट ले रहा है, दोनों के केसेस में will be termed as a landlord. So this particular line you could quote in your answers. Apart from that, they clearly stated that the definition of landlord that is contained in any definition clause for any rent act, it has to be read as somebody who is authorized to collect rent. He is merely a collector of rent. So they have simplified it so beautifully that a person for the purpose of this rent act is merely a collector of rent. In another judgment of Om Prasad Sareen versus Ajit Mehra, a person died. Thereafter, his legal heirs wanted to collect the rent from the tenant. So here in this particular case, it was held that the petitioners in this case, they are the legal heirs of the original landlord, and that is why they are entitled to receive rent from the tenant. So here the tenant failed to prove if the petitioners are not the owners, then who else will be? But still the court held that there is an existence of landlord-tenant, even if the question of ownership is not clear yet, but there is an existence of landlord and tenant relationship that has already been established, and a landlord is entitled to receive rent irrespective of his ownership. So with these two case laws, we will be capable enough to answer an exam in case it is asked from the mains point of view. With respect to pre, we need to know where the definition of landlord is provided. It is given to us in section 2D of the Act. Moving further, like I stated, that the tenant who is subletting the property will also be called a landlord in case he's doing that in an authorized manner. And thereafter we saw in the end that a specified landlord, right? Now, who is a specified landlord? Why was there a need to create this differentiation? To this, I would like to tell you the basic logic. There's a person who's serving in the union or the state services, right? So in that particular case, the person is usually posted at different locations. There might arise a need for that person to come back home. That is why they have given certain liberty with respect to eviction. और इस पे हमें पिछली बार के मेंस में क्वेश्चन भी आया था. The question was, who is a specified landlord? Discuss the right to recover immediate possession of premises accruing to certain persons under the HP Urban Rent Control Act. So I'll give you a hint here. This was to be answered with section 2I, and thereafter you had to quote section 15 subsection 2 in this, right? आज की वीडियो में we are emphasizing on the definition. We will also cover a case law with respect to the same. तो ये जो specified landlord है, it means a person who is entitled to receive rent in respect of a building, but here they are specifying on his own account. उनकी खुद की ownership होनी चाहिए इसमें, right? So specified landlord means a person who is entitled to receive rent in respect of a building on his own account. And there is an added condition. So this means the next condition is also to be fulfilled. That is, who is holding or has held an appointment in public service or post in connection with the affairs of the union or of state. So here the question arises, okay, we understand that the person is holding a position, yes. But has held के case में, of course, we know that the person has retired or is not serving anymore. But will it amount, he be a specified landlord for eternity? Or is there a time period specified? So this definition will be complete if we read it with section 15 subsection 2. So just this much part of section 15 subsection 2 is needed for us to understand the definition for the time being, right? So let's say this person has held the public service So in section 15 subsection 2, they are clarifying where a specified landlord at any time within 1 year prior or within 1 year after the date of his retirement or after his retirement, but within 1 year of the appointed day, whichever is later. So appointed day हमें कहाँ दिया गया है? सेक्शन 2A में. कौन सी डेट है? आप मुझे कमेंट सेक्शन में लिखकर बता सकते हैं. राइट, सो हियर दे आर क्लियरली स्टेटिंग कि रिटायरमेंट के 1 साल पहले या फिर उसके 1 साल बाद तक वो एक स्पेसिफाइड लैंडलॉर्ड रह सकते हैं. अपार्ट फ्रॉम दैट, अगर अपॉइंटेड डे से भी हम उनका 1 ईयर कैलकुलेट कर सकते हैं, राइट, अगर वो उस पीरियड से पहले रिटायर हुए हैं इन दैट पर्टिकुलर मैटर, विच एवर इज लेटर. सो इन दैट केस ओनली ही विल बी कंसिडर्ड अ स्पेसिफाइड लैंडलॉर्ड. इससे रिलेटेड हमारे पास केस है डॉक्टर डी.एन. मल्होत्रा वर्सेस करतार सिंह. So this is back in the year when East Punjab Urban Rent Restriction Amendment Act was applicable. So here the petitioner, he was posted as the SDO with the Rehabilitation Department of the government in which year? 1963. And our appellant, he had been inducted as a tenant in respect of the said house in the year 1968. So we see that the person was serving and he got retired back in the year 1963 और 1968 में हमारे appellant induct हुए as a tenant. So on similar lines we had a provision section 13A whereby they clearly stated that the petitioner is a landlord and not a specified landlord, and that is why he cannot claim the benefits of section 13A. So with this, we have completed our discussion of specified landlord. And now I would like to rectify. In the previous video, I had stated that the urban areas is nowhere provided in the Act of Himachal Pradesh, to which I stand corrected that section 2K provides us urban areas. The previous definition that we did with respect to census of 2011 was with respect to the entire India, right? And with respect to our Himachal Pradesh, section 2K specifies that any area that is administered by a municipal corporation, municipal committee, a cantonment board, or any area that is notified, or any area committee that is notified by the state government, that will amount to the urban areas for the purpose of this act, right? But I would highly suggest that you look into the previous video and learn about what does census 2011 provide. Reason being, हमने वहां पर statutory towns भी करे हैं and census towns भी करे हैं, तो आपको इन दोनों का डिफरेंस पिछली वीडियो में पता चल जाए. So with this we cover the definitions, and in the next video we will be covering all the leftover definitions with respect to the tenant, the residential property or the non-residential property. See you in the next video. You may subscribe our channel for more such stuff which will help you in your pre as well as mains exams for judicial services. Thank you so much.